All right, let's dive into the world of construction. But not the usual hard hats and blueprint stuff. Today we're tackling conflict avoidance and disputes. You know, the kind that turn dream projects into nightmares. And to guide us, we have the Royal Institution of Chartered Surveyors, or RICS for short.
Yeah, think of RICS as the construction industry's peacekeepers. Their advice on keeping projects running smoothly is golden. Not just for surveyors, but for anyone in the building process.
Oh, okay, so it's not just for the pros then. That makes me feel a bit better, actually. So our deep dive today comes from their document, Conflict Avoidance and Dispute Resolution in Construction. And it's part of their practice information series, right? So it's like a cheat sheet of expert insights. Before we really get into it, can you give us a quick rundown on what exactly RCS is all about?
Absolutely. So RECS is global, and they're all about setting the bar high for professionals in land, property, and construction, making sure they have the knowledge, skills, and ethics to deliver. Their standards framework ensures things are done right, consistently, and with top-notch quality.
So they're like the guardians of good practice in construction.
Exactly. Now, you mentioned this document is practice information and not hard and fast rules.
Yeah, so it's more of a toolbox of best practices that RICS members can draw from.
You got it. Valuable guidance packed with wisdom from seasoned experts.
Okay, I'm ready to open that toolbox. What's the first thing that jumps out at you?
Well, what's fascinating is how RICS approaches knowledge. They have 3 levels: knowing, doing, and doing advising. When it comes to conflict avoidance and dispute resolution, a chartered surveyor needs to go beyond just knowing.
They need to actually put it in action, huh?
Absolutely. They need to be able to do and advise.
So it's about being able to navigate those tricky situations in the real world.
Precisely. And to do that, they need to understand all the techniques for dispute resolution.
Okay, let's break that down. What are those different levels that RICS talks about?
Well, they start with negotiation, the most basic and often the most successful approach. It's where the parties try to work things out directly.
Makes sense. Trying to find common ground before things escalate.
Exactly. Then there's mediation or conciliation, where a neutral third party comes in to help.
So someone to cool things down and keep everyone focused. Focus on finding a solution.
That's the idea. And finally, there's adjudication, where a third party makes a decision that's binding on everyone involved.
Oh, so that's like bringing in a referee when the parties can't agree.
A perfect analogy. And what's interesting is that RICS emphasizes surveyors need to be familiar with all these levels, even if they're not trained mediators or adjudicators.
Why is that so important?
Because they need to know the right tool for the job. Sometimes negotiation is enough, other times you need more, maybe mediation or even adjudication. Recognizing those situations and advising your client is crucial.
So it's about understanding the landscape of dispute resolution and knowing when to bring in the specialists.
Exactly. Now, on top of that, RICS brings in a framework developed by Professor Green, highlighting 3 pillars of dispute resolution. He calls it the dispute resolution landscape.
Okay, I'm intrigued. Tell me more.
So the first pillar is all about avoidance, aligning with the proactive approach we talked about. It's about preventing disputes in the first place. Then there's the containment pillar, managing disputes effectively once they arise, preventing them from getting worse. And lastly, the resolution pillar focuses on techniques to resolve the dispute, like the ones we just discussed.
So it's a comprehensive approach to dealing with conflict, from preventing it to managing it to finally resolving it.
Exactly. And I think Professor Green's visual representation is helpful because it shows that dispute resolution isn't a linear process. You might move back and forth between pillars, depending on the situation.
Yeah, it's more like a dance than a straight line.
Exactly. A fluid process needing adaptability and understanding of all the tools in the toolbox.
Speaking of tools, let's talk about some of those conflict avoidance strategies. What are RICS's top tips for keeping things smooth on a construction project?
Well, good project management is key. RICS really emphasizes clear communication with the client right from the start.
So no more assuming everyone's on the same page.
Definitely not. It's about being proactive, making sure expectations are aligned from day one. RICS also highlights the need for realistic assessments of progress and costs.
So no more sugarcoating or burying your head in the sand?
Nope. It's about being honest with yourself and the client. About challenges, making sure everyone understands the risks.
And what about those early warning signs? How do you spot potential problems before they turn into big disputes?
RICS stresses proactive identification. Surveyors need to be evaluating the project, looking for issues that could derail things.
Sounds like a lot of responsibility.
It is, but it's crucial. They need to be the eyes and ears on the ground, identifying risks and communicating them to everyone.
Okay, so clear communication is a recurring theme here. What are some practical ways to ensure that happens on a project?
Documentation is key. RICS is big on clear, concise, and accurate records of everything: meetings, decisions, changes in scope or budget. Think of it as creating a paper trail that everyone can follow.
So if a dispute comes up, you've got the evidence to back up your claims.
Exactly. But it's not just about protecting yourself. It's about transparency and accountability throughout the project.
So everyone's literally on the same page.
That's the goal. When everyone has access to the same information, it's much easier to prevent misunderstandings and conflicts.
Okay, I'm starting to see how all this fits together. Proactive management, clear communication, and documentation. It's all about creating a collaborative and transparent culture.
You got it. And RICS also highlights the relationship with the design team.
Why is that connection so important?
Because the design team often has crucial information that impacts the project's success. Regular communication and collaboration can help avoid costly mistakes and misunderstandings.
Makes sense. It's like making sure the architects and engineers are talking to the builders on the ground.
Exactly. RICS also talks about good payment practices and record keeping.
Why is that such a big deal?
Payment disputes are one of the most common conflicts in construction. Clear invoices, timely payments, and accurate records can go a long way in preventing headaches.
So being organized, transparent, and fair when it comes to money?
Absolutely. Now, on top of all this, RICS also talks about partnering.
Oh, okay. I'm intrigued. What's that?
It's a more collaborative approach where everyone, client, contractor, and consultants, work together from the beginning to establish shared goals and understand the project's objectives.
So it's a team effort from day one.
Exactly. This shared commitment to collaboration can really minimize disputes.
I can see how that makes a huge difference. It's like building a strong foundation for the project based on trust and mutual respect.
Precisely. And RICS points out partnering is particularly effective in complex projects with a lot of uncertainty or risk.
So when the stakes are high, this collaborative approach can help keep things on track.
Exactly. And it's not just about avoiding conflict, it's also about promoting innovation, finding creative solutions that benefit everyone.
Well, I'm already seeing how RICS guidance goes beyond just preventing legal battles. It's about creating a positive and productive work environment for everyone.
You've hit the nail on the head. That's what makes RICS's approach so valuable. It's not just ticking boxes or rules. It's about fostering professionalism, collaboration, and respect.
We've covered a lot of ground in this first part, from conflict resolution levels to tips for avoiding disputes. I feel like I'm getting a clearer understanding of how RICS shapes conflict management in construction.
And we've only just scratched the surface. In part 2, we'll go deeper into dispute resolution techniques, starting with the art of negotiation.
Sounds fascinating. Can't wait to unpack those strategies and see how they can help us navigate tough situations. Join us for part 2, where we'll continue our deep dive into conflict resolution.
Welcome back. Excited to dig deeper into those dispute resolution techniques, especially the ones RICS highlights.
Me too. In part 1, we set the stage, talking about RICS's focus on proactive management, clear documentation, understanding those different levels of dispute resolution. But now let's get into those specifics.
Absolutely. It's important to remember that even with all that, conflict is sometimes unavoidable in construction. That's where these techniques come in.
Right, because even with the best plans, things can go wrong.
Exactly. So let's start with negotiation, often the first line of defense when a dispute happens. And RICS has a lot to say about doing it effectively.
Okay, let's talk tactics. What jumps out at you from RICS's guidance?
Well, they really emphasize preparation. You can't just go into a negotiation and hope for the best. You need a plan.
So no winging it.
Definitely not. RICS stresses understanding both sides of the story, not just your own.
It's like putting on your detective hat, gathering all the evidence before making accusation.
Exactly. You need the facts, the contract terms, industry standards, and you need to articulate your client's position while understanding the other side's perspective too.
That makes sense. If you can see things from their point of view, it's probably easier to find a solution that works for everyone.
Right. And RICS also talks about separating liability issues from monetary ones.
Okay, unpack that for me. Why is that separation so important?
Well, it helps you focus on a practical solution rather than assigning blame.
So instead of saying, it's your fault, you focus on the problem and how to fix it.
Exactly. Sometimes separating those issues can even help with compromise. Maybe both sides agree a mistake was made, but they can still figure out how to share the costs of fixing it.
I can see how that would help. Taking the emotion out, having a more rational discussion.
Precisely. Another key principle is focusing on interests rather than demands.
Okay, that's interesting. What's the difference?
So a demand is what you're asking for on the surface, but an interest is the underlying reason why you're asking for it.
Can you give an example?
Sure. Let's say there's a dispute over a project delay. The contractor demands an extension, while the client demands the original deadline is met. Those are their demands. But the contractor's real interest might be to avoid penalties. And the client's interest is to have the project done so they can start making money.
So by getting those underlying reasons, you might find a solution that actually meets everyone's needs.
Exactly. Maybe the client offers a bonus for finishing early. That incentivizes the contractor to work faster, while also compensating them for the extra effort.
That's a great example. Focusing on interests can open up so many possibilities.
Absolutely. And RICS also recommends using objective criteria.
Okay, we touched on this briefly in part 1, but remind me why it's so important.
It's about grounding the negotiation in something solid, not just opinions or emotions.
So not just saying, I think it's worth this much. You can point to a standard or a clause in the contract.
Exactly. Use things like industry standards, contract terms, expert reports. To evaluate fairly, it brings transparency and objectivity to the table.
I see how that prevents arguments about costs, which can really derail things.
Absolutely. It's like having a referee who can say, based on this, this is the fair solution.
Right. It takes the guesswork out. What other techniques does RICS recommend?
Well, they talk about separating the people from the problem. It's about depersonalizing things. Remembering you're negotiating with a person, not just a company.
So not us versus them. It's about finding a solution that works for both sides.
Exactly. Maintaining a respectful and collaborative tone, even when things get tough.
Okay. No yelling or name calling, even when you're frustrated.
Definitely not. RICS also suggests brainstorming different options, looking for creative solutions that maybe weren't considered at first.
Thinking outside the box.
Exactly. Be open to compromise and finding a win-win.
This is penny negotiation in a whole new light. It's more nuanced and strategic than I thought. It's not just about arguing and getting your way. It's about understanding creativity, finding solutions that address everyone's needs.
You got it. And RICS gives great guidance on how to do that.
This is great advice for any negotiation, not just construction. But what happens when those efforts stall? When do we move beyond those initial conversations?
That's a great question. That's where techniques like mediation and conciliation come in.
Okay, let's dive into those. What's the main difference between negotiation and mediation?
Well, in negotiation, the parties try to reach an agreement themselves. But in mediation, a neutral person steps in to help the conversation and guide them towards a resolution.
Like a referee keeping things fair and productive.
Exactly. The mediator doesn't make the decision, but they help the parties communicate better, understand each other's views, and find compromises.
And RICS has recommendations for mediation in construction.
Absolutely. They say it's crucial to pick a qualified mediator, someone who gets the complexities of construction projects and contracts.
So not just anyone can do it.
Definitely not. It needs special knowledge and skills. RICS also talks about impartiality and confidentiality.
What does that mean?
The mediator must be neutral, not favoring one side, and everything said in the sessions stays confidential.
Creating a safe space to be honest and open.
Exactly. That confidentiality can be key for the parties to explore options and find a solution.
I see, especially when there's tension or mistrust.
Absolutely. RICS also gives guidance on the specific procedures, setting ground rules, timelines, defining the scope.
A structured process to maximize the chances of success.
Exactly. And I think that's one of the key takeaways about mediation. It's not just bringing in anyone to chat. It's following a process designed to make communication work, to build understanding and reach an agreement.
This has been a fascinating look at negotiation and mediation. I'm seeing how powerful these can be for resolving disputes in construction.
And we've only just scratched the surface. In Part 3, we'll explore more formal procedures, like adjudication, arbitration, even litigation.
Okay, I'm ready to go deeper. Stay tuned for Part 3, where we'll continue exploring these important topics.
Welcome back to the final part of our deep dive into conflict resolution. You know, in construction, we've covered so much already. Proactive management, clear communication, all those negotiation and mediation techniques.
It's been quite a journey, but like we've said, sometimes even the best efforts with negotiation or mediation, they just don't work out. And that's where those more formal procedures come in. Right, because sometimes you need something with a bit more structure, a bit more bite. So let's talk about those procedures that RICS highlights, starting with adjudication. What exactly is adjudication, and how does it work in construction?
So adjudication is a process where a neutral third party, called an adjudicator, makes a decision that's binding on everyone involved.
So it's like having a judge, but faster.
Exactly. Speed is a key advantage of adjudication. It's all about resolving things quickly, usually in a few weeks, which can be so important to keep a project moving.
Yeah, I could see how that would be helpful, especially if a dispute is holding up important work.
Absolutely. And RICS points out that adjudication is a statutory right in the UK under the Housing Grants, Construction and Regeneration Act, meaning parties in a construction contract have a legal right to use adjudication.
So it's not just a suggestion, it's the law.
That's right, making it a powerful tool for resolving disputes in a timely and cost-effective way.
Okay, so we've got adjudication, which seems pretty efficient. What other formal procedures does RICS talk about?
Well, there's expert determination, often used for technical or evaluation disputes. That needs specialized knowledge.
So like bringing in a specialist to make a decision.
Exactly. Like say there's a dispute over the quality of materials used. You might bring in a materials science expert to evaluate and decide.
Okay, so for those really specific issues, expert determination can be useful.
Absolutely. Now, moving up in terms of formality, we have arbitration.
Okay, tell me more about arbitration. How's it different from adjudication or expert determination?
Arbitration is more formal. The parties agree to have a neutral third party, an arbitrator, make the final decision.
So it's like a private court case.
In a way, yes, but it's usually more flexible and less adversarial. The parties have more control, choosing the arbitrator, setting the rules, deciding on confidentiality.
That flexibility could be appealing.
Definitely. And RICS says arbitration can be really effective for complex or high-value disputes, especially with international parties.
Interesting. So a big dispute across multiple countries.
Yeah.
Arbitration might be the way to go.
Exactly. A neutral forum for those kinds of disputes, with a decision that's enforceable in most countries.
Now, we've talked about negotiation, mediation, adjudication, expert determination, and arbitration. What else is there?
Well, there's always litigation, the most formal option, and often the most expensive and time-consuming.
Right, taking it to court.
Exactly. Litigation means filing a lawsuit and having a judge or jury decide.
And RICS doesn't recommend going straight to litigation, right?
No, definitely explore other options first. Litigation should be the last resort, when everything else has failed.
Makes sense. It sounds pretty daunting.
It can be. RICS really stresses to carefully consider the costs, risks, and time before going down that road.
This deep dive has given me a much clearer picture of all the different ways to resolve disputes in construction, from informal talks all the way to court.
And I think the value of RICS's guidance is that it emphasizes understanding all these procedures so you can make informed decisions and guide your clients properly.
Right, because knowing your options and when to use them is so important.
Absolutely. It's like having a toolbox full of tools and knowing which one's right for the job.
I feel like I've added some serious tools to my toolbox today.
Me too. And one of the key takeaways is that it's not about winning or losing. It's about finding solutions that are fair, practical, and will last in the long run.
Well said. And remember, conflict is normal. Even in construction, it's not always bad. Sometimes disagreements can lead to good things. Innovation, better communication, stronger relationships. The key is to approach conflict with a good attitude, a commitment to doing things the right way, and a willingness to find common ground.
I completely agree. And I think that focus on professionalism, collaboration, respect, it really comes through in how RICS approaches conflict resolution.
This has been a really insightful deep dive into a topic that's both complex and so important.
Absolutely. I hope this journey through the world of conflict resolution has given you the knowledge and tools you need to handle those bumps in the road with confidence and grace.
Thank you for joining us on this deep dive. We encourage you to check out RICS's resources to keep learning. Until next time.